So this particular session will focus on the exit issues, the deal terms, exit rights, and enforceability. Before I forget, and I was talking about the audience, this program would be telecast on our television, and if some of you want to visit a television, it's called nishit.tv. It will also go on our mobile app, so you have worldwide audience, and it would be good if you can interact and ask any question, because this is really a good educative program. So let's start with a little introduction of each of our panelists. Riaz Karmali, he is partner with Pillsbury Winthrop Shaw Pittman LLP. But I would like you to tell a little bit about yourself. I think I've known you for a long time now, correct? And he's been a good friend, and it's been almost at least 12, 15 years we have done a lot of things. So thank you so much, Karmali, for coming up and being with us. Please tell a little bit about yourself, what you do.
Absolutely, yeah. Nishit and I have worked together for, at least 12, 13 years. I actually originally incorporated IP Pro back in the day. And I have a practice that's a tech-focused practice in Silicon Valley, but a global practice. So we work with companies both coming to the U.S. and also U.S. companies going abroad, and have done deals throughout the subcontinent and in other countries as well throughout the world. And recently been involved in a sale of a company to Avaya, a software company that closed earlier this year, which was a U.S. parent but significant Indian operation. So that was sort of the most recent deal, but I've done many Indian deals over the years.
Very good. Thank you so much. And maybe Stephen, everybody knows you by this time. Thank you so much. Once again, he is Assistant General Counsel and Practice Head at Silicon Valley Bank Financial Group. And Punima, maybe would you like to say a few words about yourself?
Sure. I work with Intel Capital.
I can't hear you.
All right, thanks. I work with Intel Capital. I'm an attorney in their New Delhi office. I work with a team of attorneys in Hong Kong, and I handle our investments and exits in India, Singapore, Taiwan, and VIE structure offshore investments into PRC. I do a fair bit of portfolio management. We've got about 120 companies outside of the PRC, and get involved in their exits as well. Most of our investments in APAC are somewhat strategic to Intel, and they end up being in the technology space.
Thank you so much. Vaibhav, all of you have heard him since morning. He's partner in charge of technology, venture capital, and private equity practice, M&A at our firm. And Simone, once again, she co-heads our international commercial law practice and the competition law and M&A. So let's start with the first question with you, Riaz. I think the last one should be, the first one as well. Okay. So, Riaz, what usually is the deal term, wish list kind of thing for US companies in Indian M&A?
Well, my experience, I think U.S. companies, they bring their experience from U.S. M&A to cross-border deals, so they're going to, view it similarly to the way they would in the United States. So you would, they'd have negotiated. Initially, they'll come forward with a proposal that is going to be, very pro-buyer. They might, for example, have quite a number of representations and warranties in the fundamental list, which would be, either initially uncapped or they would be capped at the deal price. And then they'd have other representations and warranties which would have a lower cap and would be subject either to a holdback or an escrow. And normally, it really depends on the context in terms of, is it a competitive deal where they had to bid to get it? Are there other buyers involved? Do they have some, additional leverage where they think they can get the best deal? I mean, you're always going to try to get the least risk-free deal that you can initially as the buyer. So, it'll depend on that. The thing is with deal terms in the U.S., they're very well tabulated. There's the ABA and there are different shareholder or representative organizations that keep essentially year-to-year lists of the deals that are happening and what the terms are, and aggregating, in terms of very specific negotiated provisions, what percentage end up in what basket. So the way the lawyers negotiate an American deal is with reference to some of those market standards. And I guess I have a question as to whether there's any such market standard available, any such tabulation, or maybe you guys keep one.
Okay, I think Weber, you can respond to that question.
Okay,
what are the Indian trends for the key deal terms and mentioned by Riaz? So also what industry standards in relation to liability caps, reps, and indemnity baskets?
Sure. So let me first take the second question first and then respond to Riaz. In India, unlike US, where everything has become very standard and you don't, when you're going into a deal, this is it, and that's how you do it. There's typically very less negotiations on that. In India, a lot of things are negotiables, right? What we have seen in terms of caps, if it's a small transaction, if it is a minority investment, or if it's a full out 100% acquisition of a small deal, your cap can go up to 100%. That is what was more or less standard at least several years ago. Slowly, when we are seeing a large transaction, or we are seeing newer transaction where the ability of the seller is very high, the caps have gone down for liability to 20 to 35%. It's still higher if it is tax. Tax is generally kept out of this cap, and tax is negotiated separately. The tax cap is separate and out of it. But if you're a large transaction, you would somewhere between 20 to 35% is more or less what we are seeing more and more of. Having said it, there are 2 or 3 different points to keep in mind. First is, if the seller is private equity player, they typically don't give reps and warranties for the operation of the business of the company. And as a result, you just have a founder who is ready to give the reps and warranties for business of the company. So even though you have a certain liability cap, it really depends on what founder is getting, because he's not going to give cap for more than what he is making in any case. And sometimes that becomes very, very critical. And that's when you look at the escrow mechanism, and I'll come to escrow mechanism in a very short time. The other caps which are relevant, for example, when you are doing a deal, you have what you call the de minimis cap, which means that what is the minimum amount after which you can claim. Typically what we have seen is that on an individualized violation basis, it's 0.1%. Gross basis, it's maybe up to 1%. Sometimes it can be lesser. It can be absolute number instead of percentage, depending on the deal size. If it is absolute percentage, if the deal size is very high, then it will be absolute value, which will be somewhere like $500,000 on an individual basis to a couple of $1 million on a gross basis. Again, depending on the deal sizes. So that is what the de minimis caps are. On the number of years the reps and warranties survive, or when the liability will remain. Generally, you will negotiate. So the buyer would want 3 years or more. The seller would want to keep it at 1 year or 18 months. What we have generally seen is 3 years in maybe about 70% of cases. In 30% of cases, it is brought down to maybe 18 months. So 18 months to 3 years is what it is. 3 years is most likely, if your negotiation skills of buyer is good, it goes down to 18 months. Or if the buyer or company is a good governance, it goes down to 18 months. So this is typically in terms of how long it will survive. Tax does survive 7 years plus the financial year over, so maybe about 8 years because that is what typically the tax department will look, can reopen the cases. And generally, since tax department starts reviewing it after 3 or 4 years, limiting it to 3 or 4 years doesn't make sense for a buyer. So that's typically it's what.
So the way it's worded in the U.S., often tax goes until the statute of limitations. So what's the statute of limitations in India?
7 years plus
7 years.
The end of financial year. So
I see.
you cover
I think
8 years.
sometimes it can go retrospective, going back to 1962. I think that, so future is, is uncertain, but past is also uncertain at times.
Now, going to some of the other deal terms which we are seeing, generally, Simon mentioned about CPs. We look at condition precedents, standstill clause, and what you call material adverse effect. These are the important negotiating items for making sure the time between signing of the deal and the closing of the deal, the buyer has certain say in it or certain way to walk out of the deal. And what we see is that depending on how early the closing is anticipated, you negotiate that particular clauses. Again, in India, a lot of things are negotiation, and I think we need to keep in mind that while a lot of people will know we will reach out to middle, they will always start with extreme and then give up to come to somewhere in middle. So both parties, if they start with an extreme, that is not unusual. Which sometimes you would say, why are we starting with an extreme position? Because we know that this is not what we're going to get. Let us start with what is most practical. India is still the graduate to that level, so I think that's something we need to keep in mind.
Let me turn to Purnima. You've done a lot of work in India, and what's been your experience on negotiating with Indian companies or promoters on the key deal terms?
So the sort of promoters that I deal with are really promoters of small startups. It could be a Series A round, Series B, or maybe somebody that's been around for 5 years. It is a complete song and dance dealing with them. I think
Bollywood.
as colorful as that. I think issue number 1 is valuation. I don't know, there was this really, if you read this, there was a really nice article about a month ago on Bloomberg about how valuations are just overly inflated. And it's basically, I think you take promoters' hopes and dreams, you multiply it by some completely random number, and then you divide it by investors' FOMO, fear of missing out, and that's your valuation, right? So I think issue number 1 is almost always valuation. 2, I think the sort of promoters you deal with depends on which sector they are in, and 2, what stage of investment you're looking at. So earlier the stages, if it's seed capital, angel investment round, or Series A round, the promoters tend to be easier to work with. But as it becomes Series C and Series D and closer to an exit, it's way tougher to get your terms in. The sectors that I look at are typically, cloud computing, mobility, e-commerce, big data, data analytics. These promoters tend to be very sophisticated. And there are way too many PE firms and hedge funds chasing a handful of companies. So again, it comes down to valuation and a few odd rights that you can wrangle. Especially, I think e-commerce is really difficult now. There are too many players chasing them. You just take what you get and you think, you forget ROFR, tag, IPO, M&A, strategic sale. You're willing to take a discount on that. You even sign up to a standard, I'd say even a 1x liquidation preference. As long as you get a foot in the door, you're happy with e-commerce companies.
Actually, a question.
Yeah. Any question?
One question
Comment? Yeah, please. Go ahead.
from one of the panelists. Is your experience with the entrepreneurs who you're working with, does it differ based upon their experience outside of India, for example, in the Silicon Valley or New York or something like that? Does the negotiation style and tenor, does it differ?
Yeah, it's completely different. I think as Webber correctly said, they sign up to a song and dance, so they start up with a position which is just absurd. then you engage an Indian law firm. If it's not experienced enough in dealing with international PEs, they take an even more extreme position. So you waste about 4 days in a negotiation room, and each party knows it's just a matter of time before you see some sense and you start talking about what's in the middle and kind of fair to both.
So we are an Oriental country, am I right, Sonia? We are an Oriental country, so everything is Oriental carpet deal. Okay, and even after the deal is done, it's not done. Sometimes. Okay, so thank you very much, Sonia, for a very good comment, Purnima. And but Vaibhav, can you just tell what are the challenges in enforcing? Because many times people would sign up anything. They think that, okay, ultimately matter will go to court of law. And as I mentioned earlier, if you cannot resolve this life, you've got next life and the next, because you believe in reincarnation. But enforcement is a very important part. And maybe, Vaibhav, you might have a few words to say on that.
Yeah, I think a little word on enforcement. A lot of time we sign up a very good deal, whether it's in terms of reps and warranties, liabilities, indemnities. I may have certain rights to proceed against certain covenants for the person if he's still there or now. So a lot of ways you will try to get agreements in rights in the agreements. But when it comes to enforcement, there is a very different ball game you need to keep in mind, right? First and foremost, we need to keep in mind, you need to decide where do you want your litigation ground to be. You know, we always draft an agreement hoping that you will never get into litigation, you will never get into a situation where you need to enforce, but in a situation you end up getting, right, you want to know which ground it would be. Again, in India, when you look at litigation, it is generally a point of how much pressure I can put on the other side so that I can negotiate a right settlement. I think that is where the litigation becomes critical. Now, if you have a good ground on litigation, you will be able to settle with him in terms which are more favorable to you. So I think that's where the ground becomes very critical. Now you have two options. Either you can do litigation in India, right? Or you can do litigation outside India. Outside, what we have normally seen, which is a preference, is to have arbitration in Singapore as one of the most commonly used mechanisms, something which the Indian companies have generally agreed. If you have arbitration in Singapore, the seat is in Singapore, then you can take the person to Singapore. If there's any violation, Singapore is very fast. Generally, we have seen arbitration get over in less than a year's time, which is fast compared to what you would see in India, which if you do it, it may go for 3, 4, 5, 6 years, and thereafter there will be more in terms of High Court and Supreme Court appeals in High Court and Supreme Court, so which will take it to a longer period of time. So people prefer Singapore as a venue to speed it up. The good part about it is that if it is in venues in Singapore or the seat in Singapore, then the Indian courts are unlikely to interfere into the arbitration award. There are very limited grounds in which they can interfere, which means your ability to enforce increases at a much higher probability compared to if it is in India. Then Indian courts have a lot of jurisdiction, which means they can interfere, and your arbitration can be dragged on for a long period of time. So time frame wise, Singapore has turned out to be much faster compared to India. But there's a downside to Singapore to some extent, and you always look into case-by-case basis to see whether in your case it makes sense or it doesn't make sense. The downside is the moment you shift the arbitration venue outside India, you may not be able to take benefit of Indian courts for getting interim injunctions. Now, interim injunction is very critical if you're dealing with certain things like intellectual property, where you're given intellectual property to someone, and you worry that he will disclose it to someone else, or he will sell it to someone else, or he will violate certain confidential information. If you have those kind of situations, then you may want to consider whether I should be choosing Indian judicial system, because if I go to Singapore and get an order for enforcement of IP, by the time I can enforce that order, that person may have already done the deal, and I may not really be able to get protection. So getting for interim injunction, if that is critical, we may want to consider India. Now, having said it, in Singapore you have something called emergency arbitration, which is also beneficial, though the enforcement of that in India takes time and is questionable, but because your final arbitration happens in Singapore, it is quite likely that that person will voluntarily follow the emergency arbitrator's order. Now, emergency arbitrator, for people, just for everybody's information, is something which Singapore arbitration will set up and give you in a couple of days' time, rather than for a year's time. So you can get an equivalent of interim injunction as a emergency order in Singapore. Other point I want to make, that even if you have won the arbitration or a court judgment for enforcement for any indemnity, one important thing you need to keep in mind is if you take any money outside India, you need Reserve Bank of India's approval. So sometimes, when you won the judgment or won the arbitration award, does not necessarily mean that you've got your money, right? And as a result, always keep that in mind, that any award you win is subject to Reserve Bank of India approving for remitting the money out. Generally, Reserve Bank of India will not say no if it's a genuine case, but sometimes it can get delayed, and sometimes if they feel that it's not a genuine case, or if something is wrong, they may ask certain questions. Generally, they will approve. I think this was what I wanted to say.
Thank you. And
Sorry, can I ask a quick question? So, Vaibhav, are you aware of cases where the RBI has actually allowed an Indian company to honor a payment and allowed remittance outside?
Yeah, I'm sure they have. I can
should
pull
be.
out, and I can pull out few thought process. But let me put it this way: there are very few cases I have come across where RBI said no.
Okay.
So putting it the other way around, it's not.
Interesting.
It will be uncommon for RBI to say no for allowing remittance of money which you award, which is there in the court, right? It's very, very rare cases. Generally, what we have seen is when RBI have questioned, is the RBI believes that this is basically a kind of a deal between two parties, and they're trying to scam the government.
But
That's the only time.
yeah, sometimes what happens, people say it's a little concocted arbitration, right? And you want to send more money outside India and then take them otherwise. So some people have this kind of facade of arbitration. So where RBI suspects that this looks like completely bizarre or something which they feel fishy, then they have a little problem. Generally, they would comply. And there are RBI guidelines on exits and stuff like that now. That makes it a little easier. So by and large, recently we have not seen much problem. In fact, I sit on the board of Singapore International Arbitration Center, and largest number of cases are from India, and within that, maximum cases also between private equity and the promoters, which is not usual in this part of the world. So I think that's something one needs to bear in mind. People in India are more comfortable with Singapore. English law is generally applied, or even if it's Indian law. The main thing is that instead of going to London, that was usually the case, or Paris for International Chamber of Commerce, now most of the people tend to go to Singapore because they feel the system is fair, the judicial system is fair, it's very speedy, and we have done some innovations in terms of emergency arbitration and stuff like that. So that's something that to take a note of. But let me turn to Simon and about exit rate. What kind of typical exit rights, Simon, are negotiated in India-focused deals? Can you just tell a little bit about?
Sure. So the exit right phenomenon is more in a situation where you're acquiring part of a company, because if you're acquiring 100% of the company, the concept of exit rights doesn't really, prevail. And in these circumstances, we see, especially in an M&A context, we won't talk about private equity and venture capital because, there are different set of exit rights available there. But in an M&A context, I think key exit rights that are looked at is the common put option. Now, in India, there's been a lot of debate as to whether the put option was actually an enforceable right at all, because the Reserve Bank of India took the view that the minute you invested into the equity of a company and you had a put option, that gave it the flavor of debt because you were not really, participating in the equity interest of the company. You had a sure short way out, which gave it a flavor of debt. And the Reserve Bank of India sort of frowned upon these rights, and very often did not allow parties to actually enforce them. But of late, we've seen a change in the Reserve Bank of India. There's been, circulars and regulations which now permit the use of the put option. What is a put option? Basically, it gives the ability to the acquirer or the investor to actually sell its shares to the existing shareholder, a guaranteed right to sell at a stipulated price. Now, the main concern of the Reserve Bank of India in terms of the put option was at what price could you actually sell. The minute you had an assured price, which was linked to an IRR-linked price, the Reserve Bank of India was concerned that, of the debt flavor of the deal. Which is why the Reserve Bank of India, whilst permitting put options now in equity deals, stipulates two things. One is a moratorium period of 1 year, and second is that you have to exercise the put option at fair market value. You can't exercise it at an assured return price. So whatever it is, the fair market value is at the time of exercise of the put option price. That's how you exercise the put option. We're not saying that Indian promoters today are ready, and I'm sure Purnima, you can throw light on whether an Indian promoter or Indian shareholder is willing to accept a put option and willing to abide by its obligation. But there were twofold issues previously. One is that the Indian shareholder would always take the protection of the law, saying it's not an enforceable contract at all, so there's no question of me honoring it. That excuse now is gone. It is an enforceable contract under law, subject to these pricing terms being met. The next sort of exit that we've seen is, of course, a call option. Now, call option gives you the ability to buy the shares and become 100% owner of the company. It's not really an exit strategy, but it is a protection mechanism should you stay in the company. Again, the call option again has to be exercised at fair market value. In a situation where the company's value has gone down and you want to do something else with the company, or there's an issue with the existing shareholder, a call option is something that you can sort of look at, especially when you know that the Indian shareholder has a lack of resources to actually fulfill a put option obligation. The third set of rights that we see is the drag-along right. Now, it's not really been tested as to how you can sort of enforce or force an Indian shareholder or any other shareholder to actually sell their shares, but it is commonly used where the acquirer has the ability to cause an entire sale of the company or its assets to a third-party shareholder, and the existing shareholder has signed up to that contract to abide by that drag-along right. Now, this is in a part acquisition. What we've also seen is not really an exit right, but a form of a deferred compensation where you have earn-out structures inbuilt into an Indian deal, especially when you're doing 100% acquisition. Now, the earn-out structure, is different in India in the sense that it is a compensation paid through the company as opposed to a deferred share consideration, primarily because of exchange control laws. Now, what's not very favorable in an earn-out situation is that it is not very tax efficient for the seller, because it's treated as you don't get the benefit of capital gains tax. You get your tax differently. It could be taxed as a salary or income in his hands going forward. So that becomes an issue. Also, it depends on how it's worded. It could be since it's a contingent payment, it could be also viewed as taxable on day one as opposed to payable or taxed as and when you actually get the consideration. So it's not very tax efficient. Plus, it's a consideration that goes out from the company as opposed to consideration being paid by the acquirer directly from its funds. So for reasons such as those, sometimes it becomes sort of not very favorable to have earn-out structures, but that's something that we've seen. Another example of balancing the deal in terms of especially deferred consideration, it's not really an exit right, is through the use of convertible instruments. For instance, you buy 90% of the company on day one, and you infuse a primary infusion into the company through a convertible instrument that has a conversion formula that is linked to maybe the value of the company, which can be exercised at a later point in time. For instance, if the company has not done fantastically well, then you dilute the shareholder completely with that convertible instrument. If the company has done well and met the parameters, the performance parameters, the dilution is less, and then you compensate that with a share purchase at the value at the time of exercise of the share purchase. So it's a mixture of these that you actually look at while structuring a deal. It's not really exit, but it's price protection nonetheless.
Excellent.
A question from the end of the table?
Sure.
Right over here. Just because we asked the questions. The issue relating to put options, the fact that they're deemed enforceable, at the same time there's the pricing guidelines that actually can hinder the value of it. That applies to what, in the U.S. And foreign investors usually use in the way of warrants and options, correct?
Correct.
So that's actually one thing that, international investors and acquirers have to be cognizant of, that they're trying to structure a deal that involves some sort of option or warrant. It may not serve their purpose because they may not get a long-term value out of it because they have to reprice the instrument right at the close. Is that right?
Absolutely. The difference between a warrant and a warrant today, you have the pricing determined upfront today. The option, you have the pricing determined at a later point in time. The only issue with the warrant structure, especially for a foreign investor coming into India, is that the warrant has to be of a limited term. It can't be more than 18 months for a foreign investor. And you have to pay 25% of the consideration upfront. That becomes, it's not such a great deal if both these things are determined today. So it may not really, I don't know, it can be used sometimes when you want to have the right to purchase at a later point in time and you don't mind coughing up 25% of the consideration today, but it's not the best deal around.
Thank you, Stephen, I think, for a good intervention. And let me again turn to Riaz.
Nishad, I think we have one question.
I have a question.
Oh, sorry. Yeah, please go ahead and be louder and tell your name.
Okay. My name is Amit. Sorry for entering late. Simon, you just said that the conversion options can be a good option to balance it out if
Yeah.
there are so, but do you have to fix the conversion price at the time of issuing the instrument, or you can do the conversion price? Because then again, you're going against the principle of put and call option.
So the beauty of it is that, although valuations is always a concern, it is less of a concern at the time that you invest as opposed to when you sort of exit. So you have the ability to sort of have a more realistic valuation if that's possible. Today, you have to determine the conversion formula upfront. But if you have the ability to sort of, because again, valuation is any internationally accepted method of valuation is something that that the Reserve Bank of India looks at, So there are two issues here. One is the actual value that you invest, and second is the value that you need to conform to the RBI. Which is a certificate, etc., which links back to the pricing guidelines. So if you have a valuation of X and you come in at a price of X plus, you can always come in above valuation in an Indian context. So the X plus gives you the ability to sort of vary your conversion formula, with X being the minimum at which you actually convert at. The X that you convert at could be 100% dilution, and an X plus gives you the 90% so that you have that flexibility.
So the flexibility will be between X and X plus.
Yes, so just to summarize what she said is that you can actually weave in the ability to revise the formula, revise your pricing in the formula itself when you file it with the Reserve Bank of India. It can be part of it as long as it doesn't go below the threshold value, which is what the Reserve Bank of India requires, which is the fair market price, the way you value, you should be fine.
I slightly got confused with this because, if we are using convergent instruments only to balance out the balance, the instruments. So suppose someone takes 70% stake and there is a convergent instrument which has been issued so that it can go up to 90 or 75
Correct.
depending upon the earnout, etc. Then whether the two instruments will be at different price if at the time of convergence, so the first instrument was at a value and then second instrument was at a value. Is this concern from the RBI?
So you can do that. There is no issue. Let me give an example. And there are situations where primary and secondary are come at a separate price. Is perfectly okay. It's very common rather, because in primary you get a lot more additional rights. In secondary you just get the shares. So you come at a higher value on the primary is perfectly fine. If you come at a higher value in secondary, also there have been cases where we have seen it was fine. And generally when let me give an example. Let's say the fair market value pricing as per Reserve Bank of India is 100 rupees. If you are buying secondary for, let's say 120, if you're buying primary for 150, right, you can come down to 100 without any issue.
Okay. Thank you.
Thank you. I think, let me turn to Riaz again. I think, what's the usual time period or expectation for an exit? Is it based on certain milestones? Can you say a bit on that?
Yeah, I think it depends on the stage of the company and on the buyer, but usually it's more time-based and milestone-based in my experience, because usually if you're talking about a private equity fund or a venture fund, they've got a limited lifespan in the fund, and they want to get an exit to their limited partners. So you might see 3 years or 5 years as sort of the first trigger date, maybe 3 years. And in addition to the types of mechanisms that Simone mentioned, which we see, I've also seen sometimes registration rights as a possible exit. If then that's dependent on the public markets. But in some cases, the investor wants the right to be able to force you to talk to investment bankers about doing a public offering. Also, I'm not sure if this works with an Indian company per se, but redemption rights, certainly if you have a company with a corporate jurisdiction at the parent level that permits that, after a certain period of time, the acquirer may want to trigger redemption rights. I don't know if does that work under the Indian company law?
So we have a buyback provision. A company can, in fact, buy back, shares of the shareholder. But there are 2 or 3 issues there. One is that by law, if you have a buyback, it has to be made uniformly to all shareholders. Secondly, you can't buy back more than 25% of the share capital in a year. And third is there are limited funds through which you can actually use to make a buyback. So there are restrictions inbuilt into Indian corporate laws that that though this is a right that you can have, there are practical difficulties in actually enforcing that right.
Yeah, makes sense. And I think, with all of these, it is, even though you might not have milestones built into the document, it is dependent on the company having hit certain milestones and also on the market at the time, because you can't squeeze blood from a stone. If there's no, appropriate exit out there commercially, it's going to be hard to find an exit.
Excellent. I think, Stephen, you have some experience of exits. Can you tell a little bit about that? And maybe Purnima, you can also later share.
Yeah, actually, we recently sold a division in India, and actually, Vaibhav was talking about what a lot of the standard terms are when it comes to the exit terms, and we found the market is right in with what you were saying when it came to kind of the levels of indemnifications, the scope of liability for taxes, and the duration of them, that liability. Enforcement was a big point that we were focused on. Our exit was an offshore sale of shares, and it was between a Singaporean entity and our subsidiary, which was in Mauritius, which was the holding company of our Indian subsidiary. And that was pretty interesting because although we recognize that Singapore is a very well-respected site for arbitration, because our purchaser was in Singapore, we wanted to be a little careful about what law as well as what what site we use. So we actually chose a different country law and different site. Not the U.S., because they said, we're not going to go to your backyard. And we said, we're not going to go to your backyard, so we picked something that we both agreed on, which frankly, the food isn't going to be as good as either the U.S. or Singapore. But you know, the language is English, so it'll actually work out just fine. But it actually was very much in line with what you described. So, and when it came to the negotiation, what was interesting is we were obviously negotiating with principals in Singapore, but they were using a very reputable Indian law firm, as were we. And so the negotiations definitely took an Indian style. But actually, because both parties were trying to work to a close very quickly, we started off with a lot of the dance that you were describing. But then we dropped it pretty quickly because both the sets of principals sat down together, and we just said, look, we want to get through this pretty quickly because there's some timing issues. Both of us, they wanted to buy, we wanted to sell. So we actually kind of dispensed with the song and dance that you oftentimes find, in part because there were two offshore sophisticated buyers and sellers. So that was our experience, but it was very much in line with what you were saying, Vaibhav.
Yeah, I think, Purnima, in India we always have a last word for a lady, The last question.
So Intel Capital has had a bunch of good exits in the past 18 months. And so the experience has been varied depending on who's buying from us. Lesson number one, always sell to a foreign investor. It's very hard dealing with an Indian party because they squeeze you on price. And it's end of the day, what you're reporting is the IRR. Lesson number two, you're going to spend 70 to 80% of your time discussing or negotiating a tax indemnity. And when you work for a foreign fund, especially for me, it's a proprietary fund, there are global rules on not giving out an indemnity, and it's hard to explain to the board of, to the investment committee that India is different. I mean, you can't have, my counterpart in Brazil would call and say, Brazil is different. So I thought one way to work around it would be to sell some of my assets from my Mauritius. It's Mauritius that's creating the trouble, right? So I thought one option would be to sell my assets from a Mauritius company to Intel's Delaware entity and have the Delaware entity actually do the exits. Very few buyers buy that. The really sophisticated ones actually make me cover the back transaction as well. And I think I would attribute this to the Indian government, the Vodafone case, but I think Vaibhav covered the issues really well. It's indemnity, baskets. Three, depending on the sector, you may or may not have a chance of an IPA whatsoever. 10% of my investments in India are in the e-commerce sector. Given the regulatory hurdles, an IPO is not an option. It has to be an M&A exit. 4, I think if it's a strategic player buying from you, the negotiation period just drags endlessly. I love dealing with private equity. The best guys to deal with are the hedge fund players. They don't even care about the company, due diligence, nothing. They don't want a controlling stake. They don't want any controlling rights, nothing. They just come in a span of 6 days, sign to close, you've got your money, you're done. If you're dealing with a private equity person, it's almost as easy, I think, maybe give or take a few weeks. If it's a strategic player, it just goes on endlessly. And Indian promoters, if it's an M&A sale, the Indian management goes over to the new company, right? So they're no longer on your side. They're not going to be out there negotiating for you. If I want to be carved out from the indemnity, I'm going to have to go in there and really negotiate. And I think, I'm not sure we keep all this in mind when we actually make the investment.
Thank you so much, I think, for insights, and really appreciate that. At this point in time, let's see if there are any questions anyone has. Okay. Oh, yeah. Name and...
Yeah, a question for Purnima. My name is Madhav. I'm a consultant and investor in India. Question for Purnima. You mentioned in passing that for the e-commerce players, there are substantial regulatory or other hurdles that get in the way of a potential IPO. Would you care to elaborate upon that a little bit?
I think there's a whole session on this tomorrow, but I'm just going to spend, thanks for the question, Madhav. I'll just spend a quick minute addressing that. The Indian government doesn't allow foreign direct investment into e-commerce companies that deal directly with consumers on the retail side, B2C. So you can invest in the B2B space, but not in the B2C space. Most companies, like if you take Flipkart, for instance, they neither have a fully B2B model nor a fully B2C model, right? It's kind of in between, and everybody does it to work with the difficult government. They typically have a wholesale company that belongs to them. They have a retail company that belongs to their aunts, uncles, cousins, whoever. And the transactions happen with consumers. Let's say investors like me put in a ton of money into the company, and I'm assuming it's the wholesale company, but the revenue is really realized only at the retail company level, right? So there's got to be an arm's length, but in reality there probably isn't. And there is no way in hell you can disclose that to the SEBI. I mean, that's as straight as I can I can respond to that.
There's an interesting implication to what you said, though, that there isn't enough of an appetite or enough money, perhaps, in the pocket of the average investor in India. If you're implicitly saying that unless you get foreign institutional investors to pick up the equity, it isn't going to go very far.
Probably not, because there's been a lot of consolidation in the e-commerce space. Flipkart acquired Myntra. I know Pepperfry was in the market. A lot of companies have just been acquiring the smaller companies. They need deep pockets. So I'll tell you what really happens. Flipkart raises a $650 million round from, say, Tiger. Amazon reads it. Jeff Bezos announces within 24 hours, I'm putting in $1 billion into India. My portfolio, one of Intel's portfolio companies, Snapdeal, reads it. It calls all the 20 investors, 30 investors within the next 24 hours, telling us that Amazon and Flipkart are going to beat us. They have deeper pockets for their marketing costs and selling expenses, so you guys need to put in money now. Right? So it's a bit of a Ponzi scheme that goes, it goes round and round. And I think a lot of it, they need capital, not so much to compete with the others, but to give really large discounts on the goods that they're selling. It's the cost of acquisition of a customer, really.
I think I agree with Purnima.
I'm not complaining as a consumer. I'm happy with the discounts.
I think we act for Flipkart, we act for Amazon, we act for Snapdeal, all three of them. Something.
And yet no conflict. Huh?
That no conflict. No. But then we see this pretty often. It's a very interesting position in Indian market today, and because of which these three companies are likely to acquire at least a dozen company each every year. So you can understand the interest in e-commerce companies is because that if I have, as an investor who has invested in an e-commerce company, you know that if if 36 companies are going to get acquired by these three companies, and if my company, my portfolio company is one of them, I'm going to get a good return. So I think that is where the key.
Yeah.
I don't know how much of you are familiar with what's called software-defined network function virtualization, and cloud and data storage requirement for so many years for various regulatory reasons. And the location of the data in what's called a open storage or software-defined storage, software-defined instrumentation, software-defined everything is going to be there. I'm Clara, I didn't mention my name. What are the issues that you are seeing or foreseeing with deals that's going to happen, with your companies or your advising companies very soon?
So first, on cloud, we have written a booklet, which possibly will be there tomorrow. I'm not sure if it's not there today for sure, but it's there tomorrow. There are a lot of.
We kept something aside, so you incentive to come tomorrow as well.
Yeah. So in fact, there on Internet of Things, on cloud computing, we have written books on the issues in legal issues in cloud computing and Internet of Things. So that is something which you will see tomorrow. In fact, we may have the whole session on some of those issues. So maybe we can talk tomorrow.
Especially there's a data storage requirement and which jurisdiction, which country, and all of that.
Yeah,
it's a very big issue indeed.
Privacy, data protection issues we are covering tomorrow.
Okay.
So we can take it.
And a quick response to what you asked about data centers. See, there's money to be made in data centers in India if they own the real estate. If they're going to lease it, it just works out too expensive. If the Indian promoter wants to buy real estate, the size that he's looking at, he's going to have to buy it from some state government. Most PE investors in the US have serious issues with respect to FCPA, anti-bribery regulations. The Indian real estate market is risky. It's very, very risky, and I would find it hard to recommend to my investment committee to go ahead. And I mean, I may respect the promoter, I may do all my due diligence, but everything depends on that one license that he needs to, the certificate that he needs when he is acquiring that property from the government, right? So we made an investment in a company in Bangalore, and I thought one way to shield Intel was to have them incorporate with a holding company in Singapore. So Intel and other PE investors have invested, we're all shareholders in the Singapore company, and the operating company is in India. I think it shields me to some level, and sometimes I think the less I know, the better off I am.
In fact, just on real estate, there's a very good question, may not directly relate to you, but what we find is that many times private equity and other funds have taken an approach that when you are acquiring a real estate, we are not going to be part of it. Okay, you get a clean slate, everything, and then we will come, because we are not party to the, The question that arises is sometimes, say, you buy real estate on record at $20 million. But within 1 year, they have cleaned up everything and all that, and now they say $100 million. So when as a fund, you make investment in the real estate company for $100 million, what is the responsibility of directors? When you look at, first thing you're going to do is to ask for a document that, your title to the whole thing. When you get into that, you also come to know that they bought it for $20 million because original purchase agreement is there. Now, question is whether what has happened in between 11 months that price has gone from $20 million to $100 million. Is this a part of the due diligence to be done by the director? So at least, because that question at least should be raised, that what has happened? Okay, so the only answer to that would be that, okay, we paid money somewhere and therefore, but this is what is the price, that we are selling at this price. Now, these are some of the trickier issues that you have to really handle on. And, so FCPA is a very important issue. In India, many a times when you talk of FCPA, they say, this is the way we do it. And you don't ask us, because otherwise nobody can do business in India. But there are people who have done business in a straightforward manner. But that's where even your acumen and the legal people also come in and try to see that how best we can do it. But this is one of the most important things. Lately we have found that there's a lot more improvement in awareness about FCPA, but still it's an issue, and one needs to be careful. I think Purnima raised a good point on that. Yeah.
I just have one query. I mean, is title insurance been evaluated in India the way we do in India, US?
Some years ago they wanted to come, and I think, I would not.
No, actually, I was going to say the
Ladies
same
first
thing.
and last.
We were looking for title insurance. It's not readily available. But our corporate land records are not corporatized yet, so it's not readily available. But we've been hearing the market, and we've had discussions with some brokers that they're looking to give title insurance for some real estate. So probably in the next 5 years, we should see a different ball game on that.
So are there title insurance companies in India which are allowed to do that?
No one really wants to give it because it's so risky.
Right.
That no one really wants to give title insurance right now. But we're seeing today that trend is sort of changing. And maybe in 5 years, even global players would be okay to sort of give title insurance, but not right now.
Some years ago, few companies tried to come into American title companies, and after doing all the work, they found that possibly they would wait for a while to come up with insurance on that. So let's see how it unfolds itself. But because even now, some states are even digitizing their information and all that thing, so that will become more easy to understand the title defects if there are any.
But you know, just on that, I think it was in 04 or 05 when DLF filed for its IPO. And I remember seeing the DRHP and reading the risk factors. And there was actually one risk factor which said, we may not be able to prove title to some of the properties, you know, listed in this document. There is no title insurance. That would be unheard of in any jurisdiction. You know, you're a real estate company going out there raising money from from the market, and you're stating, I may not actually be able to prove title.
And in terms of tax indemnities, do you have tax insurance? You know, do you see tax insurance in India as well?
So it's a good question. The market has picked up. Given the deal size for most PE investors, it's generally not worth it. I would say the larger players may explore it. You know, somebody who's doing a deal for at least above 250 million. But for smaller investments and startups, no. It's just not worth the effort that you take engaging somebody in.
We have done a lot of work in this area. And what happens is the premium shifts, you know, because I've gone through the whole rigmarole right from the time initially Mauritius. We represented all the global investors who invested in India through Mauritius, and we had gone, I remember in 2001 or so, in the Supreme Court. And before we went to Supreme Court, there was uncertainty, so the premium went up almost as high as 6%. Because it is not only tax that you insure, the penalty and the interest and everything. The next thing was, so before that the insurance was, you know, we had to say this is how it is there, but in the Supreme Court, so premium fluctuated. The moment Supreme Court said there is nothing wrong, legally or morally, in third country residents like the US, to invest in India through Mauritius for the purpose of tax avoidance. So, okay, so Supreme Court clarified in 2004, immediately there was a lot of certainty because Supreme Court judgment is a law of the land for the purpose of, you know, taxation. So there was law was absolutely clear. Okay, so insurance began to be given and became easier, and AIG and everybody. You know, but the way in which the whole thing functioned, of a global total portfolio, insurance companies have certain limited amount. Only they take this kind of high risk thing. So they have a limit up to which how much they will insure. So if the limit is expanded, they will issue more and the price is less. But the limit comes closer, more people want to take the insurance, then the insurance premium goes up, you know. So in 2004, I think lots of insurances were issued. Then suddenly after 2009 and 10, when government tried to bring in what is called direct taxes code, which is now put on shelf, you know, uncertainty came because they got general anti-avoidance provision, GAR, okay, which said you must have substance, although it never became a law, but mentally people became little uneasy about if GAR comes, what will happen to Mauritius, what will happen to Singapore, all this kind of stuff. So again, there was fluctuation, psychological fluctuation, although law remained the same. When today law is absolutely clear that if it is a Mauritius company, even if it is a shell company, Supreme Court has said, tax benefits must be allowed. But these fluctuations are, then again, Vodafone happened. So again, tax insurance became a little bit of a tricky issue. Then Vodafone succeeded. Again, at that point of time, there was more certainty. Then government brings a retrospective amendment. So there is another uncertainty. Okay. And then again, now government says, okay, there is no problem. So we will not bring retrospective amendment. So people felt comfortable. Suddenly MAT issue comes up, minimum alternate tax issue. So there became another level of uncertainty. So, you know, it's a situational. But, you know, so especially in large transactions, we have seen a lot more insurance taken. And especially when tax indemnities become very difficult to negotiate, this becomes one of the options. It may be a little expensive, but at least it is there, you know. And big problem, as was mentioned earlier, that funds have a limited life, and after that liability comes. how will you go about it? Because you can't distribute money all. If you distribute, you have a problem. Therefore, insurance is there, then you pay insurance, distribute the money, and then let's see what happens. So there are a few nuances to the whole thing, but we'll be happy to share. As was mentioned, about 25 to 40% of the time often is spent on negotiating tax indemnities. And it is not one time. Because of the nuances changing, the tax indemnity language also goes through a lot of hoopla, And but that has become an art more than a science per se. It's not that you take a one form of indemnity and sign up. Every time you have to add on more and more thing, and new situation comes and people negotiate. No, there's something called advanced ruling system. So sometimes people say, okay, we sign this, but we go for advanced ruling. So so they get faster resolution. So if you provide advanced ruling, then the next question is, if you succeed in advanced ruling, will the tax department will go to the High Court or Supreme Court against the advanced ruling? What happens in the end? So it's a 10, 15, 20 years kind of thing. You have to really, or you say, okay, you deduct tax and be done with that, but you straight away lose 22%, okay? And in addition to the exchange fluctuation, which I think was mentioned in the previous session, I think Abali mentioned or somebody else, that not only you lose on account of tax, but also you lose on account of exchange fluctuation. So, and whatever remains is taken by lawyers. So, I'm sorry for that, but that's the answer. Any other question? We seem to have excellent interaction. I think it's beautiful.
May I ask a question on tax indemnity?
Okay, fine.
What sort of caps are you seeing with the tax indemnity? Is it withholding tax, just 1x withholding tax plus fees, penalties, lawyer fees, or is it 3x withholding tax, or does it even go up to the entire purchase price? What is your experience?
Mahesh heads our international tax team out of Singapore.
Purnima, yeah.
Hi.
No,
Sure. You can stand up and show.
No, she can see.
Okay.
Yeah. No, so no, on the tax indemnity, 3x is a little too aggressive, because 3x, the logic is that 3 times the tax amount is the potential penalties. But the way we structure it is that, and of course, if the deal size is big enough, ensure that there is a legal opinion. Sometimes you may seek an advance ruling. Do everything required to ensure that penalty risk is pretty minimal, which is possible, because essentially, as long as it's a good faith interpretation of the law and it's backed by legal advice, it really mitigates the risk of penalties, right?
No, but no buyer is going to go and tell his board, I've got a tax opinion, legal opinion. They're just going to want to know, are we covered or are we not?
So penalties is something which is taken out of it. So usually the standard is 1x of the tax amount, which is the withholding tax amount, plus, of course, interest is, you can never really compute that, because you don't know when the claim will come. And of course, it's some amount for litigation costs and legal costs.
So the principle, you know it well, is that in India we have some rule of law. So when there is a penalty proceedings, basically they are considered quasi-criminal. So when you have acted on a bona fide opinion from an expert law firm, because only lawyers are allowed to give opinions, not accountants, if you have relied on a legal opinion of somebody who is known for that, then penalty 99.9% will not apply. Okay. In same way, prosecution is also dropped, because then there is no imprisonment and stuff like that, because you relied on in good faith on a legal opinion. So to that extent you are protected, and pretty much I think nobody will be able to give other kind of a view, because it's accepted position. You go to 3 top councils in India and they will have the same view that, yeah, if it's reliance on a good opinion, well drafted, okay, no penalties can apply. So there will be not a problem. Problem is that when you're negotiating, at that point of time they will bring up these issues. But internally, both the parties know that if you rely on a good opinion, penalty will not apply. So only question then remains, and tax department's position, if they win the case, then okay, penalty will not impose, but interest, because you have lost that tax all these years, so at least we are entitled to the interest payment. So that interest you have to factor in. then you take a judgmental call where you want to, because otherwise there is no end to imagining, oh, okay, it's 3 times the penalty, three times the amount involved is the penalty and stuff like that. But by and large, if there are sophisticated advisors involved, then you will be able to reach some point which you can manage, because at the end of the day, risk can never be avoided, it can only be managed. So this is something that might be of some interest to you. Good. Any comment, anything, any of the panelists you want to say? Something, Riaz, last word, all of you can, if you want to say anything, one more opportunity. Okay, fine. Anything from the audience? Because there is no difference between speaker and the audience. So that's why we all this. Everyone is a speaker here too. What? So anyone has any comment? Anything else? Okay.
I can suggest I'm a budding
Yeah, you can put on the microphone.
The middle one.
Yeah.
I'm a budding entrepreneur. Thanks for the information.
You can take closer to you.
Sure. I'm from Austin, Texas. Session is really great for the entire since the afternoon session, and thanks for all of the guests to come here and share your knowledge.
We really appreciate your patience and being with us until the end. Thank you very much. Once again, we thank Ty, NASCOM, Vicky, and all of you here for making this a great success. And we are really, really happy, as I mentioned earlier, that this is not the end of the day. Tomorrow is one more. And also whatever has been done will be recorded if you are interested in going through that again for yourself, your staff, or anybody else. We'll be happy to share the videos. And thank you so much once again, and let's have a big round of applause, not only for the panelists, but also we will have for the audience also. Thank you. Thank you. It was a great job. Thank you.